or if it's a defendant. So if you raise jurisdiction, that attaches to the applicant because you are saying to the applicant, you have come to the wrong court. It makes sense. You attack their local standard. You are dealing with the applicant. But when you then say you want to deal with this composition of the court, because applicants do not constitute the court, which judges come and so forth, that's a separate point. It can be addressed by responding to an application made. You have to do it separately. That is the basis for our submission.
In other words, it should be a shield rather than a sword.
Indeed.
What you are saying.
Thank you, my lady.
Professor Maduku, let's cut to the chase. If it is a preliminary issue, is it not?
Yes.
It's not of any great consequence to the larger issues at stake. If any of the parties, the third, fourth, or fifth respondents, were to stand up and orally apply now for an application for recusal, what would be your position? If they were to stand up now and say, my lords and ladies, we wish to apply for the recusal of the entire bench, what would be your position?
We have two answers, my Lord Justice Patel, to that. The first is that when they do that, they would have made some application which we will deal with. And our response, which is the second response, that would be an application if they stand and do that. But secondly, when we respond to such an application in this court, in the Constitutional Court, and I think that would be the same in the Supreme Court, we will simply oppose it on the basis that such a fundamental application ought to be in writing. And in fact, the point that is made in paragraph 7 of my heads is exactly that. Seeking the recusal of senior judges is, I would want to borrow an expression I have never used. It's not a walk in the park. And so we would then respond at that stage and say, well, that you are merely giving notice that you seek the recusal of judges. Put it in writing so that we get this on record. If I may tell the court, in the High Court, we have situations of this nature. When someone stands to say that the parties will normally agree on some management, that you now reduce your application, put it in writing, and then the other parties, and so some case management takes place at that stage. But very few judges would sit there to simply listen to an oral application for recusal in the High Court, but not at this level, not at this level. And that's what we are indicating in our heads. And we can show Justice Patel that if you look at the authorities that are cited in the South African case of President of South Africa, they are from all over, Australia, Canada, every jurisdiction. When you seek recusal at the level of this court, again, let me use that expression, it is not a walk in the park. Those will be my answers.
Thank you, Mr. Matuka. Can we hear now from Mr. Malaba?
Thank you, my lady. My lady, I subscribe to the view expressed by Mr. Maduku. There is no application for recusal before the court. My submission is based on a fact of there being a court application filed in this court on the 13th, which is yesterday, in case number CCZ 22 of 2021, CCZ 22 of 21, which...
What application is it?
It's an application for recusal. It's a court application.
Is it an application for recusal? Is it to this court?
Yes, to this court for this matter.
Is it an application for recusal or is it an application for leave to approach the court directly?
No.
Because it can't be made directly, surely.
My lord, my lady, it's at page 33. Any judges to whom The matter is allocated from the 2nd to the 17th respondent, hereby recuse themselves from hearing the matter under case number CCZ 13 of 21. In the event of the first respondent is confirmed to still hold office as Chief Justice and carries out...
Yeah, yeah, we have not, the court has not had sight of that. It was just out of interest asking whether it was an application for leave to approach the court directly.
It was finished to us
a few minutes ago.
A few minutes ago. It was not served earlier at all.
Who is the applicant?
The application was filed yesterday.
It was filed yesterday on the
And served today.
and served today when we were sitting in court.
And the gist of the relief sought is the recusal
of all the
judges
justices.
of this court.
Yes, of all the justices who sit, who have been cited, and those that are also not here, who were cited in the High Court proceedings in the Musa Kika matter.
So are we also cited in that?
My lady, yes, you are the second respondent, my lady.
Sorry?
You
are.
You are the second respondent, my lady.
Very well. It's news to anyway. So let that delay detain us too long because we haven't seen it.
Thank you,
It is what is before us is
it is a court application.
Who is the applicant?
On 10 days' notice.
Who is the applicant?
The applicant is Musa Kika.
But what is the point you want to make?
The point that I'm making is that there is presently no application for recusal before the court, which must be determined as an antecedent to the disposal of the matter in CCZ 13 of 21. Because
respondents appreciate that. That is why they filed
they admit,
this application.
yes, they admit that their statements in the notices of opposition do not amount to a court application, do not amount to an application. That is why they then took a separate move to make an application for recusal in writing.
And in the light of that, what then should be the way forward, Advocate Makwaliba?
My Lord, my submission at the moment is that the application has been filed as a court application. It has not been filed even as an urgent court application. It is not filed properly for determination as an antecedent to this application. The applicant in that matter knew that this matter was coming up for a hearing. He knew from the moment the applicant's legal practitioners in CCZ 13 of 21 raised the point that you have no proper application, but they did not do anything until the eve of this hearing. And that is an improper application. It cannot be considered in these proceedings.
Well, were we being asked to consider it?
That is exactly my point.
No.
You are not being asked to consider it, and you cannot consider it. I make one additional point that the Supreme Court, in the judgment of Indiam Investments Private Limited and King's Haven and others, SC40 of 2015, made the point which was made by my learned friend that the opposing papers are a shield and not a sword. So an application...
I said it 5 minutes ago.
You did. You did, my lady.
Yes, Mr.
acknowledge that.
I think your 10 minutes are up.
Thank you, my lady. Let me wind up. So it follows, therefore, that the respondents' opposing papers in CCZ 13 cannot yield an order in favor of the respondents on any point. That has to be carried by initiating proceedings. Those are my submissions.
Thank you. Yes, Mr. Shinake.
Thank you. As the court pleases. I'll be very brief in my submissions for the second respondent on the question of recusal. My understanding of the court's direction is that there are two issues to be determined at this stage. The first one is whether, in fact, there's a proper application for recusal before the court, and subject to that determination, whether, in fact, the judges, by proper application of law, should recuse themselves. Dealing with the first point first, the matter that has been set down today has been properly set down before this court. It was set down in terms of an order of this court dated the 11th of June 2021, which was issued in the presence of all the counsel that are here, save for the newcomers like Advocate Matinenga and my learned amicus curiae. It was clear that this matter would proceed today. The legal practitioners, therefore, had a positive obligation to plead their cases in respect of their respective clients according to the advice or instructions that they had obtained. If Mr. Kika was advised to seek the recusal of judges in this matter, he ought to have done so in full compliance with the rules of this court and established practice. To wit, he was required to file a separate application, either in the form of a counter application or fresh proceedings, where the relief that he would have sought would achieve his legal objective. He did not do so. The key fact that the court should consider is that when a court is faced with an application for recusal of a presiding officer, that application is premised as follows. Every judicial officer is presumed to be independent. So in other words, there is a presumption that every judicial officer is independent and impartial. The law therefore requires an applicant for recusal to put facts before the court, facts that support an application for recusal. It would appear to me, with respect, that Mr. Kika has now recognized the deficiency in the approach taken in this matter. He has therefore, on the eve of today's hearing, filed a separate formal court application for the recusal of judges. But his story gets more curious. He's actually sought the recusal of judges who are not even sitting today. Secondly, the order that my learned friend has read into the record does not support him in seeking to avoid the continuation of today's hearing. Why do I say that? There is no interim relief sought in CCZ 22 of 21. There is no application for a stay of these proceedings. The matter is filed on an ordinary basis. The matter is actually not before this court. So by pure operation of law, there is no impediment that would prevent this honorable court from ruling, which I respectfully urge it to, that there isn't an application for recusal before it. The application for recusal is pending somewhere in the registry, and all the parties here have 10 days to deal with it. In the circumstances, I respectfully aver that the position of Mr. Mapungu is no more than a delaying tactic. This court must not be unduly detained by that. Oh, Mr. Kika, sorry. My apologies, my lady. It's Mr. Kika. He's the respondent, one of the respondents. I stand guided. Those would be my submissions. And I think while I'm on my feet, it is important perhaps to refer this honorable court to a recent judgment in the High Court of South Africa, which in my humble view sets out the test that would be required should we go to phase 2. And this is the case of Bennett, Susan Hillary. Bennett,
Mr.
as in-
Chinake, why are we being lumbered with this case at this juncture?
Well, I take the point that we haven't got to that stage, and therefore I will not persist in referring to it.
While you're on your feet,
Yes,
same
ma'am.
question that I posed to Professor Maduku. Surely the substance of this matter is twofold. Whether these judges here present should continue to hear the matter,
Yes.
should hear the matter, and if they do, what relief can be granted to the applicant. Those are the two main issues we are faced with, are we not?
That is correct, my lord.
So why do you persist with your opposition to the application?
Which application, my lord?
No, not the application, with your opposition to the application for recusal on the basis that it has not been properly made.
The simple point, my lord, is that the litigant who is making those averments has filed a separate application. So to put it differently, the facts before you...
Surely, if it's disposed of here and now, we don't have to wait that long.
Yes, my lord, but the...
Isn't expedition a necessary feature in the delivery of justice?
Yes, my lord, I make 2 points. The first one is that I don't represent Mr. Kika. His counsel is at liberty to look at the circumstances and decide what to do, which may include moving an application for recusal from the bar. Should that happen, all the respondents are able to deal with that application today and place them where it can make a decision. So for the record, all of us, well, certainly for myself, I am ready to argue the question of whether any of the judges sitting today should recuse themselves here and now. It's a matter of fact and a matter of law. We have the authorities. We are able to make submissions that may be useful to the court in that regard. But it is not for us to advise the applicant on what to do. Once he makes an election, we will respond accordingly.
And it is also not for you to make those submissions, Mr. Chinake, because you are supposed to be keeping a watching brief. You didn't file any...
Yes, in respect of the merits, my lady.
Yes,
But
well, in respect of the entire matter, you were supposed to keep a watching brief and not to argue the matter, but never mind, just wanted to highlight that
Well, my lady...
Mr. Magwaliba and Mr. Chinake are supposed to be keeping watching briefs and not fighting in Professor Maduku's corner.
No, my lady, with respect, we're not fighting in Professor Maduku's corner per se. The legal position is that an application was filed seeking specific relief.
Yes, I think we keep on harping on the application that was filed yesterday. Does that preclude
No, not the one filed yesterday, my lady. The main application,
the main application
13 of 21.
Yes, but the application that was filed yesterday, seeking for the recusal of these judges, does that preclude anybody who's objecting to our hearing of the matter from standing on their feet before us and say, you can't proceed? Does
No,
that preclude
anyone
them?
can object, but the second respondent then has a right to speak.
No,
So the fact that it's a watching brief doesn't prevent the second respondent from assisting the court in respect
we
of-
already have a friend of the court, and you
Well,
were
it's
supposed
up
to keep.
to the court to decide, my lady. If you prefer me not to make the submission, I wouldn't make it. But certainly,
Isn't that what a watching brief entails?
maybe
Maybe I'm mistaken. A watching brief?
Well, I think I respectfully disagree, my lady, because my brief is to protect the second respondent's interests in the matter. Any issue that arises that affects the second respondent looks to me to address.
Even though you haven't filed any papers one way or the other for the second respondent? I'm just raising it, but
Yes, so my lady,
it's not the turning point.
Yes, my lady, so if during the course of proceedings where I have a watching brief, I believe as a legal practitioner, I have the right to speak in my client's interests should something arise which had not been anticipated. My client is still before the court. My client has a universal and unfettered right to legal representation, including in relation to any issue that arises during the proceedings. That would be my response.
Thank you, Mr. Chinak.
I'm most obliged to the court.
Thank you. Mr. Matinenka?
Thank you, Milady. I do admit that before yesterday afternoon, there was no written application filed with this court seeking recusal. The issues of recusal were only raised in the opposing affidavit by Mr. Kika. My lady and lords, the point seems to be made that a written application must always be made, as if this is written in stone. With respect, that is not the law. Mr. Justice Garvey raised the issue during the course of proceedings. Can a person raise the issue of recusal? It can be done. It can be done. In fact, I was not part of the persons who appeared in the High Court, but I am advised that my little friends simply have very short memories. Because in the High Court, an application was made for the recusal of Mr. Justice Shaw. It was not a written application. It was determined nevertheless. It is consistent with this court's approach that it needs to look at the substantive issues which will resolve a dispute between the parties, not to rely on petty procedural issues. If I may refer the court to a judgment of one of you, that is Mr. Justice Shashwari, which clearly addresses this issue. I'm referring my ladies and lords to the judgment of the Assistant Trustees for the Diocese of Harare versus Church of the Province of Central Africa. It is 2009, volume 2, at page 57. I dare say that the judge in that case does make the observation that it is appropriate that one must make a written application. But having made that proper observation, he then looks at the facts and says, look, this is what is before me, and I can still proceed to determine on the application for recusal. And the point he makes in that judgment is that it must be a written application if there is potential for dispute on the facts. And he does say in that judgment that despite this potentiality, he was still able, absent a written application, to decide on the application for recusal. In my submission, yes, the application was filed late yesterday, and it was filed late because, as I said, I was not part of these proceedings initially. But having looked at the papers, and in my assessment of the issues, and not considering that it is wrong to make an oral application, I advise that, acting out of abundance of caution, a written application should be made. At the end of the day, this court must ask itself, has it been given the relevant matter within which to make a decision? In my submission, that relevant matter is before it. And in my submission, the court can make a decision. Those are my submissions, unless, of course, the court wants to make any.
Just so that I'm clear in my mind, you are not making an oral application for recusal. You are abiding by. Sorry?
I said, I do two things. The first one is that, as I said, a written application was filed admittedly late afternoon yesterday. Hopefully it is before the court. I'm not even sure whether each of you has got a copy of that written application. But in the event that it was not circulated to all of you in time, I make an oral application to the same effect as the written application. And the oral application is consistent.
Since we have not had sight of that application, perhaps you could make the oral application
I said the oral,
in conformity with whatever submissions.
Yes, in conformity
are
with the written submission.
Do you mind not speaking when I'm speaking? Thank you. In conformity with the submissions made before the court.
Yes, and in conformity in particular with the points raised in the notice of opposition which address these very same issues.
Thank you.
Well, in the notice of opposition and the heads of argument. In your notice of opposition as well as the heads of argument, your application is made in conformity with the submissions in your notice of opposition as well as the heads of argument.
In my submission...
As well as the heads of argument.
In my submission, my Lord, the application is consistent in respect of the issues which are addressed. Admittedly, because the second...
Advocate Martinenga, I'm trying to help you. I'm saying your application conforms with submissions made, averments in the notice of opposition, as well as submissions in your heads of argument.
Application now is predicated on the notice of opposition and the heads of argument.
So, yes, I did say my oral application is consistent with what is set out in the notice of opposition.
And the heads.
And the heads of argument.
Yeah.
Because that's all you have limited yourself to.
Yes.
Yes. And we've read those papers. Thank you. Thank you, Mr. Martineng. Mr. Drafos?
My ladies and my lords, our position is that the point taken by the applicants is premature. It is premature because we have not yet moved an oral application for the recusal of the honorable justices. In that respect, with the indulgence of the court, we propose to move the oral application for recusal of the honorable justices based on the points that we make in the opposing papers, together with the heads of argument.
Yes.
Indebted, my lady.
So you accept that there is no, well, I mean, there is no written application before us. You are making an oral application.
Indeed, my lady. My lady, the written application was prepared on behalf of the third respondent. Whilst it is accepted that the point in relation to recusal may be taken as a point in limine in opposing papers, we nonetheless, on the various exchanges that we've had with the court, do make an oral application. That oral application is based on issues that are already on record, as set out in the opposing papers, together with the heads of argument. In that respect, I respectfully seek the indulgence of the court to motivate that application.
To motivate the applicant?
The application for recusal.
For now, we're considering the question of whether or not there is an application before the court for recusal. And from what you are saying, you accept that there is no written application, and you have just made an oral application.
My lady, perhaps let me
So we
deal
are not
with
going into the merits of whether or not the judges should recuse themselves yet, or if we are going to go into.
Perhaps let me clarify that. The point that we take is that the question of recusal may be properly raised in the opposing papers as was done. We draw the attention of the court to paragraph 4 of third respondent's heads of argument. But nonetheless, based on the exchanges that we've had, we now move an oral application for the recusal of the justices based on what is set out in our opposing papers together with the heads of argument. So that is the application that I now want to deal with.
No, you cannot do so now yet, because we are still to consider whether there is a proper application, whether oral in the heads or in the opposing affidavit, whether there is.
My lady, my view was that
So
application. My lady, my view was that.
Do you mind? We will get to that, to the merits.
Indeed, my lady, the problem that we have is that the respondents have already taken a point that there's no application. They've taken that point in circumstances where we have not moved an application for the recusal of the justices. So the applicants would only take a point that the respondents have moved an oral application in circumstances where they ought to have perhaps moved a written application. What is before you at the moment is that an application has not been moved. So there cannot be any opposition that respondents have not taken an application for the recusal of the judges. So in that respect, I'm of the view that that application can be moved now without the need of dealing with the issue of whether or not an application is actually being moved, because there's no trigger to activate that argument.
Yes. Thank you. So, I still maintain the position that, because I'm having problems really understanding your, because for now you're simply going to, and you have done so, you have done so to address the question raised by Mr. Maduku, that there was no proper application for recusal, a written application for recusal, written or oral anyway, there wasn't.
My lady, my recollection of
Yes.
the submissions that were made by my learned friend, Mr. Maduku, on behalf of the applicant, it was that the respondents have not moved or they have not made an application for recusal of the justices. Our submission is that that point is premature for the reason that we have not yet made such an application to merit the opposition that has been taken. So at this stage, we are saying there's no need for the court to deliberate on the points that have been raised, because they have been raised in vacuum. We have not moved an oral application. The point that can only be
But now
taken,
you have, haven't you?
Well, Mr.
I wish to.
Advocate Martinenga has made an oral application. You seem to be saying you're also making an application. Naturally, Mr. Maduku and Mr. Magwaliba and Mr. Jinake will be entitled to respond to that application. I'm not sure what else you're trying to say in this regard.
Noted, my lord. My lord, my view was that I was simply going to draw the court's attention to the various points that we take, but nonetheless, if we are going to motivate that application based on the papers, we'll afford the applicants and second respondent to then respond, and then we'll then address the court in reply in relation to that oral application.
Thank you. The court will accord them. Not you. Not you. Thank you. Yes, thank you, Mr. Dracos. Mr. Advocate Shuarara.
Thank you, my lady and my lord. My lord, paragraph 37 of the amicus heads addresses this issue. paragraph 37. In that paragraph, attention was made or was brought to the fact that no cause can be founded in opposing papers. And as there is no cause for recusal, it has to be accepted that there is no application or no basis upon which this court can deal with the question of recusal. Turning to His Lordship Justice Patel's question about an oral application being raised at this stage, I do not think my learned friends for the third respondent and the fourth respondent can actually raise this at this juncture, primarily.
Yes.
In paragraph 5, the second sentence says, recusal, it does not need an application, and so the question of procedure cannot arise in the circumstances. So in this particular instance, you have a party that has pleaded that they do not need to make an application for recusal. The fourth respondent associates themselves with the heads of arguments by the third respondent. And what does our law say? Our law says you cannot approbate and reprobate. And that appears in Zimra versus Stanbic Bank. Zimra versus Stanbic Bank, which is SC 13 of 19. And this principle of law comes from an age-old authority known as the Schlachwayo Authority, but you will find it in Zimra versus Stanbic Bank, where it says you cannot take a position that is the direct antithesis of a position you took up earlier. So an oral application cannot be moved. And we also have the authority of Schill versus Milner. Schill versus Milner. Schill spelled as S-H-I-L versus Milner, M-I-L-N-E-R. It's a 1937 authority, Appellate Division 101, and the quotation that Her Ladyship and her justices would be interested in will be at page 105, which says that the object of pleadings is to define the issues between the parties, and the parties will be kept strictly to their pleas where a departure will cause prejudice or prevent a full inquiry. An oral application for recusal, which has been earlier spurned, rejected, is inappropriate, cannot be taken at this late juncture where a party has actually committed themselves to a hearing. Unless there are other specific issues that the court would like me to